Tender of payment under UCC Section 3-604, a forgotten defense. As you know, I study many different facets of law, um, and I'm always looking for a multitude of different remedies. As Jesus once said, aren't your laws the same as my Father's, right? And so I'm always looking for the equitable remedy within the UCC. And believe it or not, a lot of parables and inferences can be drawn from the UCC, to my belief and studies and knowledge, that derive directly from the maxims that come from the Bible. And so I do study the UCC because it has its applications, and I can show you in a lot of ways how the UCC does conform with God's law. They just have a way of twisting of the language, a manipulation of the language, if you will. So if you can't stand upon it, you can't articulate it, then it finds no favor for you, right? But when you know how to see it, it changes the game. So that's why I'm showing you the UCC. It has a practical application. I can testify to it with firsthand knowledge, the way that I have used it in courts before. So again, remedy can be found in a multitude of ways, one of which is understanding the commercial world, and we turn to the UCC to understand the commercial world. A tender of payment may be defined as an unconditional offer by a debtor or obligor to pay another in current coin of the realm a sum not less in amount than that due on a specified debt or obligation. Tender of payment typically arises within the law of commercial paper when a party obligated on the negotiable instrument at its maturity date tenders the sum due to the holder. If tender is refused and the holder subsequently brings suit to collect on the obligation, the party obligated may assert the prior tender as a defense to liability for interest, cost, and attorney's fees, occurring on the instrument after the effective date of the tender. Article 3 of the Uniform Commercial Code has codified a tender of payment rule for commercial paper in sections 3-604. 1. Any party making tender of full payment to a holder when or after it is due is discharged to the extent of all subsequent liability for interest, cost, and attorney's fee. Remember, an offering of tendering of payment made and refused liberates the debtor. Okay? 2. The holder's refusal of such tender wholly discharges any party who has a right of recourse against the party making the tender. 3. When the maker or acceptor of an instrument payable otherwise than on demand is able and ready to pay at every place of payment specified in the instrument when it is due, it is equivalent to tender. Let me say that one again because I think that goes over a lot of people's head. Where the maker or acceptor of an instrument payable otherwise than on demand is able and ready to pay at every place of payment specified in the instrument when it is due, it is equivalent to tender. All right? So on these mortgages, it's always funny because it's impossible to be in arrears because the note doesn't mature for 30, 35, 40 years. All right? So after 10 years, they're trying to foreclose and say the note's due and owing, but that's an impossibility because it's a 35-year mortgage or a 40-year mortgage or a 30-year mortgage. So there are no arrears. The mortgage is not in arrears. There never was a loan, and the fact remains that even if there was, the debt's not due and owing until the maturity of the note. And ladies and gentlemen, believe it or not, we have closed a number of foreclosures down with just those 3 statements alone. Okay, because the onus of probandi falls on the ones making the claim. All right, so if they're making the claim against you in foreclosure, it's really simple to put the ball back in their court and just make 3 simple statements. There never was a loan, the mortgage is not in arrears, and the last and final statement that one could make is that all the documents presented before the court are forgeries. Tender of payment under sections 3 UCC Uniform Commercial Code 3604 has been litigated only infrequently since the enactment of the code. Several reasons may be postulated for this lack of legal attention to tender. First, it may be that tender of payment infrequently arises in modern commercial transactions. As will be seen, tender only becomes an issue when the holder delays collection of the instrument after it matures and the party obligated on the instrument desires to stop the running of interest and costs on the obligation. It is possible that modern holders promptly collect their debts and hence tender of payment does not arise as an issue. In the early days of the common law, when the doctrine of tender of payment arose, great distances and gaps in communication could easily cause delay in the collection of the negotiable instrument. The modern commercial world does not operate under similar disabilities. Second, it is possible that parties obligated on negotiable instruments are unaware that tender of payment exists as a mechanism to stop interest and cost from running on an instrument after its maturity date. Just so you know that we're not just pulling this shit out of thin air. It's not conjectural hearsay. This is the Ohio State Law Journal, all right? Of payment in the negotiable instrument setting has been ignored in legal literature. Uniform Commercial Code Section 3604 has not been the subject of commentary since the enactment of the code. Third, because Uniform Commercial Code Section 3604 of the code fails to define tender, the definition must be derived from the common law. Parties obligated on negotiable instruments may be unwilling to follow the rituals associated with tender at common law out of ignorance or desire to avoid the bother of making a tender. The purpose of this comment is to explore the law of tender of payment in the negotiable instrument setting through an examination of tender under the common law, the negotiable instruments law, and UCC Section 3-604 of the code, and to explain the lack of use of Sections 3-604. Exploration of the nature of tender of payment as it evolved from the common law to its present day form will reveal that many problems relating to tender of payment remain unresolved by the code. This comment will propose solution to those problems. 1. Tender of payment under pre-code law. Tender of payment arises in a great variety of contractual settings. For example, a mortgagor may tender a payment due on a mortgage to the bank. An insured may tender a premium due on a policy to an insurance agent, or a consumer may tender money due on an automobile to a loan company. In order to clarify how tender of payment works for commercial paper, it is helpful to illustrate how and why tender of payment may arise in this context. A. The negotiable instrument setting. Two hypothetical negotiable instruments reveal typical context in which tender of payment may become an issue. In the first, A, in exchange for $1,000 loan from B, states, I promise to pay B or order the principal sum of $1,000 plus 10% interest compound annually, principal and interest due and payable 1 year from the date of this instrument. The second instrument is a variation on the first and reads, I promise to pay B or order the principal sum of $1,000 plus 10% interest compounded annually, principal and interest, due and payable at the First National Bank of New York 1 year from the date of this instrument. In both cases, A is the maker of the note and B is the payee. As long as B retains a right of payment on the note, he is termed the holder. The difference between the two notes is that the second instrument is domiciled, that is, payable at a place specified in the instrument. Notes may be domiciled anywhere, but the most common domicile is a bank. The first note is payable on demand anywhere. In either case, B has the right to collect $1,000 plus 10% interest 1 year from the date of the note. The problem is that B, the holder, is not required to present the note for payment to A, the maker, on the date of the note's maturity. A's obligation to pay the principal and interest continues whether B collects on the date provided for in the note or 10 years later. Early English law established that makers of notes payable on demand had no right to presentment of the note for payment at its maturity. This rule was in contrast to the laws of checks, which required prompt presentment by the holder for payment. Courts, however, did adopt the check rule for instruments domiciled at a bank. Since notes domiciled at a bank were analogous to an order on the bank to pay the note, the English courts took the view that presentment should be necessary. This distinction between domiciled and non-domiciled instruments did not survive in the United States. In the 1839 case of Wallace versus McConnell, the United States Supreme Court refused to require presentment for payment of domiciled paper. When the suit is against the maker of a promissory note payable at a specified time and place, no demand is necessary to be averred, upon the principle that the money to be paid is a debt from the defendant that is due generally and universally and will continue due, though there be a neglect on the part of the creditor to attend at the time and to place to receive on demand it. The result was that makers had no presentment rights in the United States, regardless of the type of promissory note. The resulting disadvantage for the maker is that if the holder delays collection of the note after it is due, interest continues to occur on the note. In the sample notes, at the rate of 10% compound annually, if the holder delays presentment for a substantial period of time, and if the note is for a substantial principal sum at a high rate of interest, the hardship placed on the maker may be very great. The maker's difficulties are further exacerbated when the original payee on the note is no longer the holder. If the note is negotiable, B may have sold or given the note to C in satisfaction of a debt. B, by endorsing the note over to C, relinquishes his right to payment of A's debt. It is now up to C to collect on A's obligation. What I just explained to you is the dealer selling the note to a third party. The third party now becomes a factor, which would be C, which would carry the fiduciary obligation and responsibility of collection from A, but A doesn't know C and has no contractual nexus with C and therefore has no obligation to pay C. So the burden falls on C, which is the factor, to collect from A and try and prove that somehow he has rights to collect. All right. But when B, the dealer, sold the note, he never gave A the value of the note, and thus the rights from A, being the drawer, never transferred to B, and therefore B could never transfer the rights to C. All right? Okay. Especially with notes payable only after a period of years, the note may have changed hands many times. Thus, the maker may not even know the identity of the holder. Although domiciling the note assures the maker that the holder, whoever he may be, must collect at a place known to the maker. The ships placed on the makers of negotiable instruments spurred creation of a mechanism by which makers could stop the accrual of interest on the note caused by the holder's delay in presentment. The law of tender was the answer. B. Formula requirements of a tender of payment at common law. A tender of payment is essentially an offer by the maker of the note to pay his obligation to the holder when it becomes due. Yet a tender of payment is really more than an offer. A tender, while having many of the characteristics of any offer, is, in the contemplation of the law, more than an offer to perform the obligation required of the obligor under the terms of his contract. In other words, tender is a broader concept than offer, the former including the latter. Every tender includes an offer, but every offer is not a tender. What then makes a tender of payment more than an offer to pay the sum due on the note? The common law worked out various requirements that must accompany the offer before it becomes a bona fide tender. The elements of the offer. At common law, an offer could be a tender only if it was unconditional and manifest ability of the maker to pay the holder the sum due on the instrument. A tender of payment, in other words, has to be more than a hollow offer by the maker to extinguish his obligations. The unconditional nature of the tender could be destroyed by tendering the sum subject to a counterclaim against the holder. A maker could insist, however, that the holder perform a statutorily imposed duty without destroying the unconditional nature of the tender. Where it is the duty of the creditor on tender of payment to do a particular act, the offer to pay may be coupled with a demand upon the creditor to perform such acts. Ergo, in a case where, by statute, it is the duty of the creditor to give a release on tender of payment, a release may be demanded, for it is the performance of a duty imposed by law. The unconditional offer by the maker had to be for the sum owing at the time of the tender. Older courts insisted that tenders are always to be considered stricti juris. If a tender is not legal in every aspect, even a court of equity will not support it, nor supply a defect. Thus, if the maker failed to tender the exact sum due, the tender was defective. Modern courts, however, have relaxed this requirement somewhat to approve a tender of a reasonably approximate sum to the holder. It was clear at the common law that the maker had to tender payment to the party to whom the sum was owing. If the original holder of the note had sold it or transferred it to another person, and the maker knew that the original holder no longer had any interest in the note, the tender had to be to the new holder. In the absence of a right to prepayment, the maker could not tender payment before the note became due. And if the tender occurred after the maturity date, the tender had to include interest on the note up to the date of tender. 2. Methods of tendering payment. Makers of non-domiciled notes faced considerable difficulties in making a tender if the holder could not be easily located. The Supreme Court in Texas in Bookham versus Great American Insurance Co. of New York stated, at common law, where no place of payment is specified or fixed by law, the rule is that the tenderer must seek the tenderee and make a tender to him if he can be found by the exercise of due diligence. The question then became one of assessing the due diligence of the maker. One case did conclude, however, if the holder had left the state, there was no duty on the part of the maker to follow the holder into another jurisdiction in order to tender payment. The ease of making a tender of payment was increased with respect to domiciled instruments through the doctrine of constructive tender. The maker could effect a constructive tender by having an adequate sum on hand at the place of payment specified in the instrument. The United States Supreme Court in Wallace versus McConnell officially approved the doctrine of constructive tender when it wrote, "Should the maker not find his note or bill at the bank, he can deposit his money to meet the note when presented, and should he be afterwards prosecuted, he could be exonerated from all costs and damages upon proving such tender and deposit." The doctrine of constructive tender evolved as a way of relieving the maker from continual presence at the place designated in the note. It was clear, however, that regardless of whether the note was domiciled, the maker did not have to tender when it was certain that the holder would reject it. This rule was based on the equitable principle that the law will not require the doing of a useless thing. The state of Iowa has enacted legislation to aid makers of non-domiciled paper in tendering payment to an unknown or absent holder. The statute allows the maker to leave funds on deposit with a court for the holder. By tendering the debt into court and giving notice, the maker can effect a valid tender when the holder is absent or unknown. This statute is unique in extending the possibility of a constructive tender to makers of non-domiciled instruments. Given the potential hardship to makers of non-domiciled paper when the holders are absent, this statute makes practical sense. When we return, we'll be talking about tender of payment, keeping the tender good.